Hello, good afternoon, and welcome to the law. This is your legal light. This is your health law. The Constitution in Article 24, Clause 1 says, every person has the right to work under satisfactory, safe, and healthy conditions and shall receive equal pay for equal work without distinction of any kind. We deal with the work relationship, the duties, and the responsibilities on this very special day, which is the reason tomorrow, as a worker, you have the opportunity of rest. May Day or Labor Day, is it? Welcome. I'm Samson Ladia Nyanini. I'll be right back with my guest. The employment relationship can be one like getting into a marriage. It's often always sweet. But in the process, certain things may happen and they may be bitter. The relationship may turn bitter. How do you avoid all that? If you know your duties, if you know your responsibilities, both as an employer and employee, it is possible to avoid this. And this is the reason my very good friends are joining us this afternoon to help you on a very special day like this for workers. Ekuya Eguakum is managing partner, Kede Law, and Stephen Osaikisi is head of Greater Accra Regional Secretariat of the National Labour Commission. Ladies and gentlemen, good afternoon. Thank you very much for joining us.
Good afternoon, Samson.
Great.
And your team.
Thank you. Right. So, what we always do to begin the show is what we call the Law 101. And on the Law 101, we are looking at the constitutional provision, Article 24 of the Constitution 1992, Clause 2. It says, every worker shall be assured of rest, leisure, and reasonable limitation of working hours and periods of holidays with pay, as well as remuneration for public holidays. Periods of holidays with pay, as well as remuneration for public holidays. Tomorrow is a public holiday. Why is it a public holiday, Kia?
It's to celebrate. May Day is always a day set aside for workers. We all know, historically how far we have come. Left to human beings, they would wish servitude of all other persons. So we've come here because together with the International Labour Organization and all other organizations have come together to ensure that there's a day set aside for workers to come to. It's a day of rest for workers. And a day we have set it aside, and it's a day that workers come together.
Right.
Tomorrow we'll see lots of march past activities
right.
going on.
Right.
Yes.
Steve, as a man who is at the Labour Commission, who sees, workers who come fighting. When they were starting, you were not there because they were happy with each other. Then you see them come fighting. How significant is this day, May Day?
Well, I think that it's significant in the sense that it's that time where, as Ghanaian workers, we're able to sit down and take stock and ask ourselves, what have we done so far? And then in going forward, what can we do better? So in as much as you see a lot of, like my colleague mentioned earlier, you see a lot of march passes and other commemorative activities. It's also, like I mentioned, the time for us to just sit back a little, see what we are doing wrong and what we can do going forward to make things better for all Ghanaian workers.
Right. So internationally and here in Ghana, by law, this is a statutory public holiday when workers are supposed to rest and reflect, as he said, and workers' leaders. You'll hear them tomorrow making all sorts of demands at the government more particularly and employers. And sometimes they do say something about the workers themselves, what they should do as far as their duties and responsibilities are concerned. So that's what we are looking at, the employment relationship, the duties and the responsibilities. But I began by reading Article 24, Clause 2, where it says, every worker shall be assured of rest, leisure, and reasonable limitation of working hours and periods of holidays with pay, as well as remuneration for public holidays. What does this mean? It's in the Constitution. What does it mean?
It is in the Constitution, and is also reflected in Section 10, in there, where you have the rights of the worker. So,
Section 10 of?
Section 10 AB of the Labor Act.
Okay.
Yes, Act 2003, Act 651, 2003 in there. I mean, the first thing is even to ensure that you get employed in the first place. So once you're employed, it, like you mentioned, the employer-employee relationship should be taken serious. So once you get engaged as an employee or a worker, like you rightly said, like any other relationship or a love relationship, you have expectations for going in there. I mean, the expectations must be put on board right from the beginning. This is what I expect you to do, and this is what I will do on my part. And one of the conditions in there is to ensure that once you're working, an employer has engaged a worker to come in and do certain described, or what you call your job description. Okay. Once you're doing that, the law says that you can't be working indefinitely. You can't be working without any end. So there must definitely be some rest periods. When you go under the Labor Act, it says that you must, for instance, work between a 40-hour week. Yeah. So within the week, you should not do anything exceeding 40 hours. Anything exceeding 40 hours should be considered overtime. So that is what the law expects. Of course.
Overtime and paid for.
And paid for.
Okay.
So, I mean, that is what the law says. And then, of course, it's a 24-hour period, but you can't be on your feet 24 hours during the day. So there must be intermittent rest periods whilst you're working. Of course, it's how many days in a month? We have 20 working days in a month, but you can't be working in there. There must be times where you must take some rest. And of course, when you're resting, you should be paid for those rest periods, including public holidays. So that is what it says in the law. And
Steve, the provision begins by Clause 1, that every person has the right to work under satisfactory, safe, and healthy conditions, and shall receive equal pay for equal work without distinction of any kind. Many are reading my lips as I read this, and they say this is a facade, at least in Ghana. What does it mean?
Well, I wouldn't say that the general impression is that this would constitute a facade, because I wouldn't say all is perfect within the labor front, but clearly following the passage of the labor law, a lot of things have changed. So you realize that in times where all of these things were not necessarily catered for, because of the act now, employers are now keen on making sure that these things are present, because you don't know when the Labor Department officers will walk into your establishment, or you don't even know when the Labor Commission itself, through any of its officers, would come in to say, we want to do some quick employee audit.
You say you don't know when the Labor
Commission
might come to the inspectorate, or
the Labor Department. You know, they have an inspectorate division.
Okay.
But as a commission, because we're also trying to be proactive in our dealings, now we don't want to sit back and say we're waiting for the dispute to happen, for somebody to walk in and say my conditions of work is not really that good. So
it's not satisfactory.
It's not satisfactory. It doesn't meet those conditions. So occasionally you would find that the officers of the commission would just go out there just to satisfy
unannounced visits.
Unannounced. Just so that when we're able to bring management and workers' representatives together, we have forehand information of what really is on the ground. And it helps to resolve the disputes as and when they come up. Okay. So it is not a facade.
Okay.
We're all working together to see how we can bridge the gap. There's a gap, I'd admit. But work is being done to ensure that that bridge that gap is closed.
Right. So I started with clause 2 of Article 24, and I've gone to clause 1 of Article 24. As a worker, I must be assured of rest, leisure, public holidays, limited hours of work. Then it says, I should work under satisfactory, safe, and healthy conditions, and I must receive pay, and so on and so forth. Do these constitute duties or responsibilities, and who is bearing them?
There are duties, and that is what I wanted to even correct, add to what he said. He said employers are keen. In fact, they are not supposed to be keen. They are obligations.
Sure.
What they are obliged to ensure. To ensure that workers work under safe and healthy conditions, we have what you call the Factory Offices and Shops Act. It's a 1970 Act. And so that if you have, for instance, the labor inspectorate from the labor department going there, what are they going to inspect? The conditions and provisions made under the Factory Offices and Shops Act. That are there any machines there that could be injurious to staff? Are there any kind of spillages? Especially when it's a factory? Is the environment healthy enough? Are there any gaseous substances that could be injurious to, the lungs and all of those. So these are what the labor inspectors are supposed to go in there.
So what that brings me to is, what are the duties and the responsibilities of the employer and the employee?
Okay, that's very good. Now, like we said, it's a free world. An employer has his business, he set up his business, and he decides he wants to bring someone on. So when you go to Section 8 of the Labor Act, 1, it says that, the employer has the right to employ someone because it's my business. So once I have my business, I have the right to. So when you go to the graphic and other, you find people's, various advertisements for various skills requirements and all of that. So they have the right to employ, they have the right to discipline, transfer, promote, and of course terminate your appointment as well. Once they have the right to employ, they can't terminate you. If you're not doing the right thing, they can't terminate. 1, and then 2, they have the right, because it's their business, they have the right to formulate policies regulating how they want their business to run and to execute plans as well, and then set up programs on how they want the organization to run. They may also have the right to modify, extend operations. So now and then you may have situations where companies may decide that, okay, we started with this, but we are expanding our operations into other sectors or whatever. And they can cease operations. We've seen that all the time. You are in the media, so you hear that all the time. And they can determine the types of products or services they would engage in. And then when it comes to their duties, 1, they are supposed to provide work. Because once I have an establishment and I say that I'm employing someone, I'm supposed to provide work. Because you don't expect the worker to come and sit in virtually the whole day not doing. There must be defined work that when they come in, they're supposed to do. And then you're supposed to provide them with appropriate materials and equipment. If you come in, you're supposed to be provided with, let's say, set of computers. I see all the equipment here and all that. It's the employer's responsibility to ensure that you must be provided the right tools to enable you execute whatever work you've been employed to do. And then that's where it comes in, pay the agreed remuneration. Okay, you've come in, you're an accountant or you're a cameraman. This is what, based on your skills and everything, capacity, capability, this is what I would pay you. So once we agree, then you are supposed to whatever mode of payment or whatever, you're obligated to that. If I say that I'm going to pay you at the end of the month or on a weekly basis, on a daily basis, the worker is supposed to do that. And then we have spoken about that already. It's explained that you must ensure that you are free from personal injury whilst you come into work. And this falls on, there are calculations for all of this under the Workmen's Compensation Act. That's a 1987 Act, right? On how, assuming there's any injury arising out of work or whatever, ways of calculating all of those. And then once you come in, because society is dynamic, work is dynamic, and things are changing. Things become obsolete very quickly, don't they? I mean, my phone, I think within the next 2 years, my phone will be obsolete. Right. So once you have that, they're supposed to be retraining you because things are changing, society is changing. So let's say you come in, you're using...
That's a duty of the employer?
Yes.
To retrain you?
Yeah, retrain you.
You bring your skills in, then I pay you for your skills.
Yeah, you bring your skills in, but you remember that. Okay, so that's why I say when you decide to, let's say, modify your operations or you want to, and then you're supposed to train people to...
It's a duty.
If Joy FM decides to go digital,
like super digital,
super, then you're supposed to train everyone.
Okay.
Joy FM is supposed to train everyone.
They're not supposed to go and employ others who already have that skill and say you don't fit anymore, get out.
On that score, you then would say that Joy will be leading themselves into an unfair practice because at the time that you were bringing all of these people in, you saw them competent enough to fit the role. So if there's been changes, like Council said, there's been changes in terms of the technology and all of that, and people out there already have the skill. Nothing stops the employer from bringing those people in. However, that is where the need for the training and retraining comes in, so that those who are already in the system are also given that opportunity to be trained and retrained so they can match up to those who already have the skill.
Okay.
Yes.
So we have looked at a bit of the duties, the rights of the employer and the duties of the employer. Let me come to you. You are the one that every day you are sitting there and solving the problems, and an employer says, my worker hasn't done this, my worker hasn't done that, or an employee comes to you and says, my employer hasn't fulfilled this right, he hasn't fulfilled this duty towards me. What are the rights and the duties of the worker? Okay.
So as we read out Article 24 earlier, that largely captures all of the rights of a worker. But I think there are two more. So there is that right where the worker is able to form or join a trade union of his or her own choice.
Okay.
And then there's also the right to receive information related to his work. Because if you need your workers to conform in a certain way, some communication or information must go in that respect. So that would add up to the rights that a worker...
So you are saying those we read earlier are rights of the employee.
Yes.
Working under satisfactory conditions. Working under safe and healthy conditions. They are your rights.
Yes, they are rights.
As a worker.
Yes.
Having rest, leisure, reasonable limitation of working hours, periods of holidays that should be paid, public holidays you should be paid. Those are your rights.
Those are your rights.
Okay.
In addition to forming or joining a trade union and really getting information that is related to
and receiving pay. And it's also your rights.
Yes.
Okay.
Yes, you're supposed to receive pay.
It's like your rights.
Yes. You are selling.
Nobody can do anything about it.
No.
Okay.
So that does it for the rights. But when it comes to the duties,
she spoke about the obligation of the employer to retrain.
Yes.
Is the training and retraining part of the rights of the worker?
It is part of the duties of a worker, plus his right as well.
Okay.
So in as much as you enjoy the right to be trained and retrained, it is also on you as the employee to tell yourself that things are changing. All of a sudden, now everything is on hand. Laptops, iPads, everything. So I should also on my own acquire certain skills that will help me do these things. So that if my employer at any point decides that I want to introduce these elements into the workplace, you are trainable.
Right.
So in as much as it is your right to be trained and retrained, you should also position yourself in a way that your training and retraining shouldn't be so hard on your employer to carry out.
You mentioned receiving information. How is that a right of the worker?
So ideally, if you don't know in the world of work, now if you don't know that this is how things are supposed to be done, ideally your employer finds it difficult to whip you in line if you're going out because you don't know. So you'd find that there's a policy on maybe attendance,
okay,
but it is in the HR's drawer. You haven't received information related to your work in terms of attendance. So that is why the law is saying that it is your right as a worker to receive relevant information that is peculiar to your work that you're doing, so that at all material times, you cannot go under the umbrella of, I didn't know that is how things
So
get
it's
done.
my right.
Yes,
So I have to demand it if it's not giving.
If it is not there, please ask. That's why Madam mentioned earlier that, so it's not about employers having a keen interest because they are under certain obligation to secure the relationship somewhat with a written contract of employment. Okay. That ideally serves as the minimum basis of receiving information that is relevant to your work.
Okay. So he's taking us quite a bit of time on the rights of the employee. Now, give us a bit of the list of the duties, and then he can also continue with some of them.
Okay. So one of them, you're a worker, you have been engaged. You're expecting to be paid, so you must work conscientiously for the...
What does that mean, work conscientiously?
I mean, you don't come in and just... You've been engaged to do an exact job description. You must put in your all. You must work hard. You must put out your best skill to make sure that you're giving out your best output or performance.
You should ensure the employer is making profit and not losses.
Yes. So like you said, it's a two-way relationship. Once the employer is paying you, you must give out your best skills ever for the betterment of the organization. You must report to work regularly and punctually. And this is very important. That is why in some workplaces, I think there are time sheets and all that to record, because the employer is supposed to ensure that when I think we'll go a bit further on, they still have to pay you. Because if they have engaged you to come and work, let's say 8 to 5, they're supposed to pay you. So within the 8 to 5, you're not supposed to be just leisurely working around and not doing anything. So report to work regularly and punctually. Enhance productivity.
Enhance productivity.
You must enhance productivity. How are you ensuring? I've seen places where it's not about regularly and punctuality, because you go to certain organizations, you may find someone coming 8 to 5, but they're being productive.
Once your employer agrees the time you're supposed to come in.
Yes, but within that period, you must be productive. So at the end of the day, how much have you put into your work? Not just filling the time space, but how much productive have you been in there? And then you must exercise due care in the execution of your work.
Due care.
Are you protecting the properties of your employer? Are you ensuring that your...
it belongs to the government.
And
you drive the vehicle anyhow, break it.
And what I find sometimes, I mean, we all know. We all know.
The computer, you break it, you don't care. The chairs,
we leave air conditioners on. Even when you go to offices, sometimes you may go overnight and things are switched on, electricity is running out because it's not yours. Especially one other thing that workers do, wastage, paperwork. You know, things that you go and maybe photocopies, so how much cost? You're costing so much to the organization. Can you enhance productivity can you exercise due care by making sure that, even also make sure that you don't do things that will be injurious to your colleague workers as
Right.
well.
Steve, let him continue some of the list because I can see that list is quite a bit.
Yeah.
So enhancing productivity, being punctual, being regular, working conscientiously. These days, and taking due care, of the work machinery, implement, and tools. These days, somebody can come at 8 if you say they should come at 8. But being productive
That's what the question
has always been the question, right?
Yes.
Yeah, we come to work with 3 phones and even the office computer. The first thing we open is
WhatsApp.
Facebook,
WhatsApp.
And YouTube.
TikTok.
Right, YouTube, TikTok.
That's what the TikTok we will do on the phones. But the YouTubes, the other YouTube can be educational and purposeful if you want to. But I don't know, but in the generality of what I have seen over time, most of the time it's either Nigerian movies or somebody is looking at how to outsmart your partner. How to, not how to be productive at work.
Okay.
You barely find a lot of Ghanaian workers using these social media, these various social media outlets.
To enhance their productivity.
Very few people do. But like I have already said, YouTube, you will find a lot of material on literally everything we do, from how to be an effective front desk person all the way to the very top. But how many of us are taking advantage of these things? So if you're going to use the internet not to enhance productivity, you will find that at some point your employer will stop providing internet because they have realized that over time, its usage is not pushing the vision and the mission of the organization.
But the employer is supposed to provide me the tools and materials to make me efficient.
So I have given you a computer. Ideally, let's say you're a front desk person. So person X walks in, you key in, person X has walked in to come and see person Y. You're done. You don't necessarily need internet to carry out that function. So if the employer goes out of its way to make sure that all of these things are there, because for me as an employer, I would want to make sure that you need the appropriate raw materials, machinery, and tools. Internet is part of those things. So if all of those are in there, it is on you as an employee to make sure that I am using it to enhance productivity. I am using it to make sure that my colleague who I share a desk with or the production line with is catered for. So I protect him, he protects me. That's how we're able to weave around our duties together with our rights as well.
Samson, I wanted to mention something. There are occasions I've seen them, sometimes they even use working hours, especially those who are studying whilst working, use office hours for their assignments and printing of their...
Use the office paper to print the loads of books that they are supposed to read.
It happens. It does happen.
It does. I wouldn't say it doesn't happen.
Right.
It does happen.
Right.
Yeah.
So if you do that, it means you are breaching your duties.
True.
And can I add one more? You're supposed to obey lawful instructions.
Instructions. Why lawful instructions?
Well, some instructions can be unlawful. So let's say we share a desk. There are certain materials that is for her and materials that is for me. Or we're both expected to carry out certain functions at the workplace. So if my supervisor walks in and says, go and take over the gentleman behind the camera, that's not my expertise. I'm not a camera person. Maybe my work is to ensure that the bottles are filled and filled right. If you tell me to go and stand behind the machine to check if the machine is working properly, you are putting me in an awkward situation. That's instruction that a worker can refuse, and the worker will not be wrong. And that's why the law says that obey lawful instruction. So instruction that ideally doesn't go against your terms and conditions of work.
I'm the accountant.
And the law as well.
I'm the
law.
accountant.
Like the accountant, you say, see if you can let it add up.
We can do what is called tax avoidance, but not tax evasion.
Not tax evasion.
We feel that there's too much tax we have to pay this month. If we pay all of the tax, you people, I can't pay you. So find a way to remove some of the zeros as far as the tax is concerned. That's an unlawful instruction.
That's an unlawful
You shouldn't obey it.
Yes, and an employee who decides to go against an unlawful instruction cannot, you have all of the protection of the law, because then your employer cannot say, because you failed to massage the figure so it does look good, I am terminating your appointment. No, your employer doesn't have the right to do so.
But they can terminate you without telling you why.
Well, they can, but the moment the person comes into the Labour Commission's office, then you as the employer, the Labour law would require you to tell the Labour Commission why you decided to let the person go without assigning the person reason. If the person doesn't take the matter up, then it ends. Right. But if the person comes to the commission, then there is that requirement of you to explain to the commission, not the employee.
Right. So if you're just joining us, this is The Law. It is your legal light. It is your help law. We're dealing with the employment relationship that often starts very smoothly, nicely, interestingly, and then sometime later, before you say Jack, then it's becoming a bitter, sour relationship. And those helping us to educate us, remind us, and so on, Ekuya Eguakun, who is managing partner, Kede Law, and Stephen Osaikisi, who is head of Greater Accra Regional Secretariat of the National Labour Commission. So you know you have the right people here in the studio. At the right time, we will invite you to bring your questions, and they will answer them. But so far, they have outlined your duties as a worker, your rights as a worker, and your duties as a worker. They've also outlined to you the rights of the employer and the duties or the obligations of the employer. Now, these duties and rights by both sides, does that mean if I don't fulfill, one doesn't fulfill his side of it, then what? Yes, Ekuya.
Then the relationship breaks down, because you summarized that when you began. I mean, the expectations of what the parties want in the relationship must be clear from the onset. So you set up your business, you know what you want the worker to come in and do. And you know, that is why the law expects that there must be a written contract. So the written contract must specify everything in there. Even, you know, there are businesses that have certain cultures. You know, you may even not. So that is why when you go in, and sometimes in the written contract, there might be like a probation period. It's like dating someone, right? The probation period is like dating. I mean, should I call it dating? It's an opportunity for you to see whether I really love where I'm going. So it's an opportunity for you to get in, because it's not just the tools. You're going to be working with other persons. You have certain job descriptions and all of that. So it's for you to get in there and decide that, look, I'm happy with what I'm doing. I mean, sometimes you have your own internal conflict where you're working in a place where you get in and realize that what is happening there actually conflicts with your principles and orientation and everything. So once you get in there and maybe you realize that I cannot fulfill A, B, C, D of what the employer wants, of course, then there's the relationship will, if you're not able to communicate. That is why it states in there that there must be a channel of communication between the employer.
Open channels
of communication between the employer and the employee. The employer must make it easy for you to be able to sit with them, communicate your concerns. I mean, it should run either way. So that maybe when something you're not happy about the situation, you should be able to communicate. And then if there's a way of ironing it out and settling, why not? I mean, any relationship is mendable.
Yeah.
So let's take, for example, the duties of the employer. And among others, you talk about the duties of employer is to provide work, appropriate raw materials, machinery, equipment, and tools. They are supposed to pay their agreed remuneration at the time and place agreed in the contract of employment or collective bargaining agreement, or by law or agreed between the employer and the worker. They must take all practicable steps to ensure that the worker is free from risk of personal injury. I think the two of you emphasized that, or damage to his or her health during and in the course of the worker's employment or while lawfully on the employer's premises. Develop the human resources by way of training and retraining of the workers. Okay, so supposing I've been exposed to risk in the workplace, supposing my human resources is not being developed by way of providing training to equip me with the skills when things are changing, then it means the employer is not fulfilling his duties.
True.
Therefore, what happens?
Well, two things can happen. I think Madam mentioned the first part where then it would mean that the relationship would have to, it will break. And so parties would have to go their separate ways. The other part is that in an establishment where you have the workers represented by a union in that respect, you would find that the union on that level would write to management to say, these are the lapses that we have seen when it comes to the general conditions in terms of our members, their social and economic welfare. And so we would want to have a sit down with management to discuss what can be done to address the particular situation that is on hand. So if it is about the fact that the human resources is not being trained and retrained, if it is about the issue of the employer failing to ensure practically that the workers are protected from any sort of injury in carrying out their duties, these are some of the concerns that in a unionized environment, you would find the union itself take up with management. If the environment is not unionized, you will find that even the workers themselves can be proactive enough and tell management that these lapses we think would not inure to not just our benefit, but also the benefit of the work as it stands. And so it's about time management took some steps towards looking at how best it can resolve those challenges.
Right. Interesting there. We are opening the phone lines in the next 2 minutes for you to join us and ask your questions of our guests about your duties, your rights, and your responsibilities as well, and what can be done about all of these. As we observe Workers' Day, I'll start with you here. As we observe Workers' Day, what is it that from where you sit, you know, you are kind of the arbiter, you know, every day, like grumbling couple are coming to you and you are settling and trying to help them to resolve their issues. What for you is important to note in the employment relationship as far as the responsibilities and duties are concerned?
Well, I believe that it is the fact that both parties should be able to position themselves where, if they don't know, they take avenues to get to know. Now, why am I saying this? A lot of times people come to you and you can tell that their understanding of the law that is keeping the employment relationship is very minimal or absent, totally absent. So now what we are trying to encourage people is that the Labour Commission is there. Take advantage of the institution. Walk in there. If it is that you need some understanding of how the law is supposed to work, then visit the Labour Commission's offices spread across a few regions in Ghana for now. And then the officers there would be in a position to assist you to get to understand what it means or what the various provisions in the labor law means. Because if you misapply, it is as much as going against the law in itself. So it would be fair that the parties to the employment relationship position themselves first to understand the law that regulates it. And then secondly, look at the terms and conditions that they have both agreed on to guide the relationship. Once that is properly done, you realize that the issues of I don't understand you, you don't understand me is brought down to a certain minimum.
Okay. Right. I'm asking the same question of you, but in the same time, I'm announcing that the phone lines are open now. So you can join us with your questions and whatever it is that you may be going through that you want some assistance. As we go into the holiday for the worker, of course, for the employer too, both are having a holiday. Yes. What is it that you, from your experience as lawyer, you interact with workers, you interact with employers, and you are seeking to uphold the rights of a worker, the rights of the employer, and so on? What would you like to say?
Thank you very much. I think he's already said, and I'll just add it to it. Once you decide you're going to open an establishment or a business, one of the important things you should do is not just having an operations person, but you should have a very strong HR, human resource department, because the human resource department is the pivot between the employer and employee. If you don't have a very strong human resource organization, department or officer or whatever, that's where we have these little challenges. Because what a human resource unit is supposed to do is to ensure that the parties, one, know the expectations are set down, because they are supposed to be the, let's say, keepers of the human resource policies, or ensure that those informations are disseminated. If there's no one, at least there should be an officer in there. So once you decide that you're going to go into this relationship, both parties must understand and know what the law regulates, but then realize that the issues stem from the fact that the parties do not even know what the law expects them to do, their rights and responsibilities. If they do, then under the law, they can sit down and negotiate without the need for intervention, third-party intervention, which is the, of course, there must be some way for the Labour Commission to do anyway. But then the law expects the parties to even start their own negotiations. But where we know our expectations, there won't even be need for a third party, like a marriage relationship. If we understand what we are supposed to do, we don't need a third party sometimes. So one, the law is key, and I'm very glad we are doing it. Thank you very much for inviting us, because we don't know the law. We don't know what we are supposed to do. So once this is a step in the right direction, and we take it up from there.
You said people can walk into your place, the Labour Commission, wherever they find your offices, and they can get help to appreciate what governs the relationship. So they should be doing that even before they get into the workplace, not when trouble comes.
Well, ideally, that should be the case.
That's if they want free lawyer. So they come to you, ask for you, is government place or free. You will do that for them.
You get paid.
You do that for them.
Government pays you to carry out your work.
Yeah, but what I mean is that if they are going into unemployment, they can come to you when there's no problem at all.
Okay, so I've had situations, especially with the regional office in Tema, where people have worked in with their contracts of employment. That, okay, so I have this job, but I want to understand what this provision means, what that provision means, but I can't afford a lawyer. So I liaise with our public affairs unit in the head office. We set up an appointment for you. You go. They run you through everything, so that the moment you append your signature,
you know what you are getting into. Let's take a call from Martha. Martha, you're calling us from Obuasi. Let's hear you. Hello, Martha.
Good afternoon.
Good afternoon. Let's hear you, Martha.
I'm calling from Obuasi. I wanted to find out, in case I'm an employee and then I get a steady leave to go and say I'm a nurse, and I get a steady leave to go and pursue a physician assistant course. And then after completing, you come back, and then the level that I was at the nursing, how should I say? In promoting me, I am worse than the one that I was in. What does the law say about that?
Okay. Thank you very much. So the person goes for further studies, and sometimes you return either to an empty desk and there's a problem, you actually don't have work to do, you don't know what to do with yourself. Sometimes, as you say in your case, there is a promotion because you have gone to do something with leave, and therefore you have to be upgraded. But the upgrade doesn't fit what you are entitled I don't know how that happens.
It happens all the time, and I've had a series of those coming. You see, we've seen the obligations of the employer. It does not include that. The employer is supposed to train you. But if you decide you want to go and fail, unless it's an employer who is funding your
Yes, we are talking
leave.
about where the study leave is approved. She says
There's a difference
that
between
situation.
approved but then being funded. You know, there's a situation where the employer would say that there's a vacancy coming as, let's say, head of department. Let me go and train you to come in. So that one, the expectation is that they are promoting and funding your steady leave. So you know that you're coming back to a position. But where you decide and they just say approved, it's not guaranteed. It's just for you to go and further your
with that,
studies.
but let's hear Adam. Hello, Adam. You're calling us from North Kaneshi.
That's not good evening.
Let's hear you.
Something about my employee. Actually, I was employed by National Youth Authority last year, June.
You mean your employer, not your employee?
Employee rather, sorry. It's National Youth Authority. And something we were given an appointment letter and we were sent to Kofoidia bedtime hotel for a training session. We the new entrance or the new students. Some small incidents happened during our. We were grouped into. We were asked to do presentations, and during the presentations, some small skirmish happened. And when we came back, my boss got peeved, and ever since that time, I've been apologizing to him by different forms of, medium. And he later on, terminated my contract. And ever since then, I've been very, very, I don't know, devastated. I don't know how.
Adam, you are saying that you had work to do, but you didn't do the work to the satisfaction of your boss, and your employment had been terminated.
Yeah. The issue is, if you were going to do a presentation, I saw some small errors in our.
Okay, thank you. You are understood. Thank you very much, Adam. Adam calls us from North Kaneshi. Right. So, Ekia will continue with what you were developing earlier. I don't know if you want to add to that, but Adam's situation too. Yes, so the earlier question.
All right. Well, I think that Ekia had literally done justice to.
In most government employment, so to speak, the rules are there, or not even private employment. There are rules there. You are allowed to take study leave, and then you go improve yourself. When you come, because of the improvement you have achieved, then you go a certain notch higher in your employment.
That is in the general situation. However, if you go and improve yourself and you return, but the opportunity or where you are going to go, there is no vacancy there, you cannot be promoted. So your promotion is staggered up until such a time where those who are already ahead have also moved up. Then you can come and fit in.
Okay. Adam says he went to do work and his boss was not satisfied with the work. As a result of that, he's been terminated and he's not happy. Of course, he will not be happy. I'll take this call from Sam. You're calling us from Teshi. Sam, let's hear you. Sam, go ahead.
Yeah. If I want to know something concerning shift worker. If you're a shift worker.
What worker? Shift worker. Okay.
Yes. Yeah, I want to know whether in the scheme of things, what do you call it? Weekends like Sundays, Saturdays are also included in the calculation of the work, like normal duty.
Okay.
And then secondly, I want to know if overtime has been worked. Let's say you work 20 hours apart from your normal 8 hours. I want to know whether your employer can use his discretion to pay you how much he or she likes other than that 8 hours. This is what I want to find out.
Okay, but this shift work that you are talking about, That's what you do from Monday to the next, throughout the week. Is that it?
Yes, sir.
Okay,
But
thank you.
sometimes you go, but after your winter when you are coming, sometimes your resumption date also falls in the weekend. And I want to know whether that one is calculated. You can use that one as it, or you treat that one as it.
Thank you, Sam. I'm sorry, but I wouldn't be able to pick another call because if we do that, we'll not be able to exhaust the explanations that we are giving to you. Right. So let's get to is it Edem
first?
Yes.
The grounds of
So for Edem, because we do not know the other side of his story, I would at best advise that he visit.
No, he's saying it didn't go well. He admits himself that he made errors in the presentation, and his boss just doesn't like it.
If he admits by himself that in carrying out his
We're talking a while ago about training and retraining.
Yes, but you see, if he admits that he didn't carry out his work well, and so as a consequence, his employer has had to end the relationship.
Despite the pleas that he has done.
Despite all of the pleas. Then our attention would probably be on the nature of how he was let go, not on the issue of whether he has gone to plead or not. Now we've gone beyond that.
All right.
So the focus would be how he was let go, the process leading to his exit. That is where, if there are any lapses, he may have some respite under the labor law. So, like I already mentioned, until we know what the other side of the story is, away from what he has already admitted, it will be difficult for us on the table now. So he should go to the head office. He said he's calling from North Kaneshi.
Right.
So he should come to the Rage office in Accra. He should go to the Public Affairs unit and get to speak to the people there. If there's a
Can I
situation,
add
Right,
to
thank
that
you.
also?
Yes.
I mean, under Section 15 of the Labor Act, the employer has the right. I mean, that's where you have termination. And then when you come to 15C, it says it can be terminated by an employer, one for sickness and accident, assuming you come in and you're ill and you can't work. And then also where you're on the incompetence of the worker. So if at some point the employer thinks that you can't really
You're not competent
enough to do the job for which they have, they can terminate you. But they must prove the incompetence. But then what is I've noticed happening within most serious organizations is that maybe when you're not performing, they may put you on what you call a performance implementation plan, just to like the training. Just
Give you an opportunity.
To, why would you
or find you something else?
Because it takes a lot to actually get someone on board. So
All right.
if you have someone who's
before
not
time runs
performing,
out
why
on
don't
us, let's go to Sam. Sam is the guy who works shift
the
worker.
overtime and shift
yes,
situation.
the overtime, the pay, can it be discretionary?
So overtime pay cannot be discretionary, because if you've done the standard 40 hours, then any hour away from the 40 is what is calculated and paid to you as overtime. So the employer cannot say in a given month you've done off head, you've done like 4 hours or 5 hours of overtime.
Okay.
But in calculating, I will pay you to reflect 3 hours. That will not be fair to the employee.
And the shift to...
And then the shift work is also tied to the 40-hour-a-week thing. So whether you're resuming on a weekday or on a weekend, know that upon resumption and when I go off again, if I put it in 1 week, am I doing the 40 hours or I am doing less or I am doing more, for which I'll qualify for overtime?
30 seconds. Time is up.
I'll just say, like we have said, we are doing this just to educate the public that, look, there are rights and obligations. If we know what they are, there will be fewer labor unrest. There will be, the relationship will get better.
Right.
It would improve. So,
And
let's all get on board.
Always seek help once you don't understand. That's one of the things I picked from Stephen Osaikisi here. The Labour Commission's places are available elsewhere. If you think that you don't have a lawyer friend who can give you free stuff, walk to them. So Stephen Osaikisi is head of Greater Accra Regional Secretariat of the National Labour Commission, and Ekuya Eguakum is managing partner, Kede Law. I'm Samson Ladia Yenini. This has been your law. It's your legal light. It's your health law. And the show runs again tomorrow at 11 a.m. So you can join us.